The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today to this hearing on the federal courts. I'll now recognize myself for an opening statement. Some opening statements are read from the notes. Some are read from memory, and some are read from the events of the last 6 months. Today's hearing, although it will cover legislative agendas beyond specifically the expansion of the federal court to deal with the amazing backlog and the necessary expansion of the court, I think it's important that the opening statement set a tone for what we want to accomplish. In the last Congress, under the Judges Act, a bipartisan, bicameral effort was made, and it succeeded. In my 24-plus years here in Washington, it was the first time I ever saw a bipartisan, bicameral bill vetoed by a president. I believe it was a short-sighted decision, primarily made by staff, or perhaps by a sense that one had to do it because so much had been said in the past. But it didn't have to happen, and it shouldn't have happened. The carefully crafted legislation before us today that will be undoubtedly marked up and voted on the House floor in the first few days of this Congress was acceptable to all sides because the principle that in the House version 8 years and in the final version in concert with the Senate 10 years, that at least 3 administrations, 2 to 3 presidents would have an impact on it. That in fact, the order of the the order of the judges was determined by the Judicial Conference's need in order of priority and by the availability of facilities to house those judges. Those kinds of decisions do not change overnight. And although I expect a small change potentially in March, when the Judicial Conference gives us an update, it might increase by a few. I doubt that it'll decrease. But we will adjust that if the bill has not yet been signed into law. It has been decades since we made a major addition to the court. And the caseloads have grown. They've grown to more or less, for the common person, 1,000 cases a year per judge. Now, the federal court prioritizes criminal ahead of civil, but there's no question at all that criminal cases are being pled out because there simply isn't enough capacity in the court. And civil cases are being delayed or forced to endlessly go through what we used to call a do loop of, well, go negotiate again, go try to settle, because in fact, the judge doesn't have the 2 weeks it would take for a complicated civil case. This and more are the reason that we came to an understanding between chairman and ranking member of both parties, of both houses in the last Congress. Now, having said that, you will hear today, I suspect, that in fact, my colleagues are no longer interested in that. And there is one thing that has changed. For the first couple of appointments, clearly President Trump would have the lead. But I want to make a point here today. I'm a Californian. In California, the district court decisions are not made by the president alone. The 2 senators, under the long-standing and not overturned decisions on the blue slip, have real impact. And I have watched under Republican administrations for years the careful negotiation to find an acceptable conservative leaning, but acceptable to one or both of my senators in order to lift the blue slip. That process that requires my judges, judge candidates, and U.S. attorneys for that matter, to spend a lot of time meeting with the home state senators has worked, and it isn't expected to change. So even in the first 2 or 4 years of this legislation, there would be not one side or the other. This is not like a Supreme Court justice or the expansion of the Supreme Court. It doesn't reflect a massive change, just the opposite. Unless the Senate and the White House remains in one party's hands for a decade, which hasn't happened in any modern time, this will in fact be a piece of legislation that will reflect judges of both parties. And I just want to contrast that. The bill that was unanimously supported in the Senate, and even after the election, received 29 votes by Democrats, including many of my Californians, when it came up after the election. I believe those 29 Democrats voted based on the court's needs, putting country ahead of party, putting the court ahead of party. In contrast, I sit here with my ranking member. He's a friend, and at times we can work together. But I do remember that during his time in the majority and another president, his alternative was not to reintroduce a bipartisan bill that spread over 10 years and answered the needs requested by the Judicial Conference and not one more, but rather his bill did exclusively district court judgeships, 203 of them, not 60-some, all of them in 2 years. In fact, he had 25 co-sponsors on that bill, all in one party. I will not repeat that just because we have the majority. I will not suggest a bill that both parties shouldn't take, just the opposite. I've learned that if we're going to have a piece of legislation, it has to be balanced and it has to be nonpartisan to the greatest extent possible. Nonpartisan to the greatest extent possible. We can never take party completely out of the process, but we can ensure that the unknown exceeds the known. Today, our witness will speak of exactly that the judges are needed, that they've been needed for a long time, and that the impact on justice in America has been affected by that. I know that, Judge Simkovich, that you will experience undoubtedly some questions that are outside the scope of this subcommittee, and perhaps even outside the scope of all the legislation we may talk about that is germane. I would explain to you, and if you haven't seen C-SPAN over your few years, they may talk for 5 minutes. You may answer the answer that is relevant to what you came here for. And I say that because I expect that most people will understand that the questions should be germane to your expertise and to the subject matter. But if they're not, each member has their 5 minutes. Let them enjoy it. Answer that. I will give you time to answer a germane question if necessary, and I will not ask you to answer questions that are outside the scope of this hearing. And with that, I recognize the ranking member for his opening statement.
Thank you, Mr. Chairman, for holding this hearing. And one of the things that I have found to be delightful in being an attorney and in transitioning from the rules of evidence and civil procedure or criminal procedure into the legislative branch and hearings and, those rules that we abide by as lawyers don't apply. And so you can expect, relevancy and those kinds of issues to perhaps pop up. But as I say, they are not mandatory. So this hearing is another step in a decades-long scheme to capture our referees of justice, to make certain our third branch is so deeply loyal to one man that our system of justice cannot possibly work without him. Our colleagues want us to believe that their sole focus is to strengthen our federal judiciary. But we know the truth. The truth is, when they had a chance last year, they put politics first. The Judges Act of 2024 was a fair bill. It was premised on a good faith bipartisan agreement that the first set of judges in the bill would go to the next unknown president. The bill removed all politics from the process because we understood that politics is the reason we have gone so long without more federal judges. And, I put forward a bill to establish 203 judgeships in accordance with prior request from the judicial branch. For some reason, the Judicial Conference has altered those numbers of late and been a little more conservative about what they're asking for in terms of numbers of judges. But it's clear when you look across the country that that 203 number would do the judicial branch much more justice than 50 to 60 district court judgeships. And I look forward to one day right-sizing our judiciary, which has been neglected for so long by the legislative branch. It's been since 1979, actually, 1990, since we've done appreciable numbers of authorizations for new judgeships. And so for 30 plus years, we've been needing more judges. And I stand ready to do that at the proper time. But this bill and the way that it has come forward is nothing but politics. Our bill, or this bill last session, removed politics from the process, as I said, by ensuring that when it passed, we would not have known who the next president was. But when it became somewhat iffy and things looked that they would go the other way, then my colleagues on the other side of the aisle decided to hold up on this bill until after the elections. And then once the election was held, the result known, then they decided to press forward with this legislation, injecting politics into the process. Judges and judgeships were not important to Republicans then, but they are very important to them today. Their guy is now in the White House and this proves once again that what I said last Congress is true. Republicans only want to add new judgeships when they can rig the game in their favor. This blatant attempt to stack the deck shouldn't surprise us. What we are witnessing today is the culmination of a plot that began 50 years ago in the early 70s with soon-to-be Justice Powell when he wrote, quote, "The judiciary may be the most important instrument for social, economic, and political change," end quote. And of course, that quote was taken from the Powell memo, where Lewis Powell recommended that we needed to put corporate power over the needs of the individual. And so that began a decades-long crusade to concentrate power in the hands of the few at the expense of the many. This created the foundation for the meticulously constructed plan we are now watching play out in real time by the Trump-Musk administration. Donald Trump is laying waste to our democratic system. In just 36 short days, the Trump-Musk administration has sought to unilaterally reinterpret the Constitution, bequeathing new powers to itself out of thin air, all while publicly undermining the judicial branch's previously unquestioned constitutional power to, quote, say what the law is. To me, none of these developments come as a shock. When you put a president above the law, like the immunity decision effectively did last year, he will behave like it doesn't apply to him. But all is not lost. Despite what many MAGA Republicans think, just because Trump says it's true doesn't mean that it's true. Our framers intentionally constructed the United States government with three separate and distinct branches of government to check and balance one another. That way, power would never be concentrated in any one branch. Practically, this meant Americans would be protected from the autocratic whims of one petty man and his billionaire co-president, no matter how many years after the Constitution became the law of the land. So while we watch the Trump-Musk duo cosplay as king, we Americans know something they don't. Time has caught up with Lewis Powell's scheme. The clock has run out on the far right's attempt to overturn our democracy. But our 250-year experiment in self-governance will succeed only if Americans continue to believe that judicial independence means that judges are not subject to pressure and influence. Americans must believe that justice cannot be bought by billionaires with gifts of lavish vacations and luxury motorhomes. Americans must believe judges are free to make impartial decisions based solely on law and fact, free from fear and retribution. Our independent judiciary is the backbone of our democracy, and I, for one, will not just stand here and let the Trump-Musk administration try to dismantle it one branch of government at a time. So if my colleagues across the aisle came here today in good faith, I say, welcome. Let's work together to find a compromise to help strengthen our third branch of government. Let's have a good faith discussion about the needs for more judges, starting with the next unknown president, and I yield back.
I thank the gentleman. I now ask unanimous consent to enter into the record a number of bills. H.R. 1526, the No Rogue Rulings Act, which limits the ability of district court judges to issue nationwide injunctions. The H.R. 1109, the Litigation Transparency Act of 2025, which requires disclosure of third-party funders. The draft of the Judges Act, which is identical currently to the bill passed on a bipartisan, bicameral basis in the last Congress, and H.R. 4886, authored by the gentleman from Georgia. And I would say that since in the last Congress, everyone agreed that a bill that allowed for either Trump or Harris to determine the next judges and was completely acceptable until it turned out that it would be Trump going first. But it was, in fact, either would do it, and we agreed to that. But if the gentleman agrees during the markup, I would be happy to substitute H.R. 4886 and the 203 judges if that's his wish. Without objection, so ordered, and we now go to the chairman of the full committee, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I just wanted to thank you and our witness today for coming on this, particularly the chairman, the important work you've done on this bill and other bills. Some you referenced in your unanimous consent request, but increasing the number of judges is vitally important to the judicial branch of our government. We all understand that. And we did have a bill that every single Democrat in the United States Senate supported. And when it was brought up after the election, granted, several Democrats supported it then. It's a good piece of legislation. I hope we can pass it. I hope we can find a way to make it to law and do what everyone knows needs to be done. But I just want to thank the chairman again for his hard work, great work on this issue and so many others. And with that, I yield back.
The gentleman yields back. Does the ranking member of the full committee seek recognition? The gentleman is recognized for his opening statement.
Thank you kindly, Mr. Chairman. Welcome, Judge Timkovich. I'm delighted to see you, and thank you for joining us today. We've convened because of a broken promise, and I don't mean Donald Trump's promise that egg prices would be lowered immediately on the first day of office. Of course, they're now more expensive than they've ever been in U.S. history, and I don't mean the promise to end Russia's filthy war on Ukraine on day one. Everybody knows that Donald Trump has now declared that President Zelensky is a dictator and that he started the war against Russia, even though we've got tape of Donald Trump at the time declaring Putin's war on Zelensky as an act of genius. But no, I refer to a promise of the old-fashioned legislative variety, the kind that Congress used to run on when our word was our bond around here. Democrats and Republicans agree that the courts need to have more federal judges. It's been more than 3 decades since we passed a law to increase the numbers of judges on the bench. We had a bipartisan deal last Congress to give the courts the added judges they need. Our stalwart ranking member, Mr. Johnson, and our distinguished chairman, Mr. Issa, worked on a painstaking and honorable bipartisan deal to create a bill that would have spread additional district court judgeship appointments recommended by the Judicial Conference over multiple presidential administrations, beginning with the next unknown president. That was the key. Pass the bill before the election, so neither side, no one, would know whether this party or that party might benefit in the short term. The Senate upheld their end of the bargain and passed the bill on a bipartisan basis last August. Then, the House GOP leadership suddenly broke the promise and refused to bring the bill up for a vote before the presidential election. In other words, before the winner of the next election was known. Instead, they waited to know who would be president. If it was Harris, they would oppose it. If it was Trump, they would support it. So now, of course, they support it, itching to appoint loyal MAGA judges to the bench to uphold the lawlessness of Elon Musk and Donald Trump, which has already elicited more than 25 temporary restraining orders and preliminary injunctions across the land. They are very happy to talk about creating new seats on the federal bench. They broke their deal. They've undermined justice in the courts. We were willing to enter into a fair deal because we believe in equal justice under the law. Our friends seem to believe today only in heads I win, tails you lose. If my GOP colleagues want to do it the right way, the fair way, and the way that they agreed to do it last year, let's do it. I've got the exact same bill, the precise bill we all agreed to last year, drawn up for this Congress, and we're ready to support it. This is the deal we all agreed to last year. The number of judicial appointments, Mr. Chairman, is exactly the same. The order of appointments by the states, exactly the same. And just as before, these appointments would begin with the next president, whoever that may be, right? It could be J.D. Vance, it could be Hank Johnson, it could be, if the Constitution changes, and I know some people are itching for that, it could be Donald Trump for all we know. Whoever is the president, we would do it, but we don't know. That's the whole thing. We're in the Rawlsian original position here. And just as before, these appointments would begin with the next president with unanimous bipartisan support. Please join me and Ranking Member Johnson today in moving to seriously fix our federal judiciary without destroying it with last-minute party politics. And if you can't support the exact same agreement we all entered into, then we must call this hearing out for what it is, a power grab. A week ago, President Trump signed an executive order declaring that he and the Attorney General will interpret the law for the executive branch. That statement cuts directly against the decision in Marbury versus Madison. And this is what I want to ask you about today, Judge Timkovich, so I'll give you a little forewarning. I want to talk about Marbury versus Madison. There, the Supreme Court said the judiciary could order Secretary of State Madison to deliver a signed judicial commission to William Marbury, even if the president told him not to. Remember, Marbury versus Madison is Secretary of State James Madison, not President Madison. Jefferson was the president, and he was telling Madison not to deliver the judicial commission that had already been signed and sealed, though not delivered. Chief Justice Marshall said, "It is emphatically the province and the duty of the judicial department to say what the law is," debunking more than 2 centuries ago the delusions of executive supremacy in interpreting the law that are circulating in Washington today. Former Trump Chief of Staff John Kelly told the press that President Trump, quote, prefers the dictator approach to government. Candidate Trump told Fox News host Sean Hannity in December of 2023 that he would be, quote, a dictator on day one. Just last week, the official White House X account posted a picture of Donald Trump wearing a crown and proclaiming, long live the king. He must have forgotten about Tom Paine, who he actually had the audacity to quote on Inauguration Day, who said that in the autocratic societies, the king is the law, but in the free societies, the law is king. The law is king. We overthrew monarchy in a revolution, and our Constitution explicitly bans the award of titles of nobility. President Trump has been hard at work removing safeguards against lawlessness and corruption. He's been gutting the career civil service and replacing it with an army of sycophants. He's illegally sacked 18 inspectors general, the people responsible for rooting out waste, fraud, and abuse. He's been slashing into independent and bipartisan agencies charged with protecting the rights of workers, the integrity of elections, the safety of consumer products, our bank deposits. He's been ordering career prosecutors to carry out unlawful orders in criminal cases to test whether their loyalty is to the Constitution or to him personally. He's been firing people who refuse to bend the knee, including staunch conservative Republicans. He's been threatening FBI agents for doing their jobs and investigating members of violent extremist militias who beat cops as they mobbed the Capitol in their drive to overturn the 2020 election. He's attempted, with the stroke of a pen, to revoke birthright citizenship, which is enshrined in the 14th Amendment. He's shut down agencies created by the Congress, which he has no power to do. Now, our GOP colleagues who have a slight majority in the House and the Senate have done nothing to stand up for Congress's powers under Article 1. Instead, they've surrendered to this president who's trampling the powers of Congress. Republican Senator Tom Tillis shrugged off Trump's power grab and laughed it off. Quote, "That runs afoul of the Constitution in the strictest sense," he said, "but it's not uncommon for presidents to flex a little bit on where they can spend and where they can stop spending." Despite the GOP's abdication of congressional authority, there's still something that stands between Trump, Musk, and their dreams of tyranny: the independent judiciary, which is why we're watching in real time as the Republicans, putting their loyalty to Trump and Musk over their oath to the Constitution, turn on the federal court system. The attacks on the judiciary did not come out of nowhere. For decades, the Federalist Society has sought to undermine judicial independence. Meanwhile, some of the same donors who fund right-wing candidates' political campaigns are funding right-wing justices' vacations, further undermining the court's credibility. But recent statements made by President Trump go further. They threaten to abolish our system of checks and balances. Vice President Vance has posted that judges aren't allowed to control the executive's legitimate power. And Elon Musk has repeatedly undermined the judiciary on social media, saying things like activist judges should be removed from the bench, or there's no justice and no judge is greater than the consensus will of the people. Not to be outdone, President Trump posted, "He who saves his country violates no law." But here's the good news. Despite...
Is the gentleman prepared to summarize?
I'm prepared to summarize.
I
Thank you,
appreciate
Mr. Chairman. You guys have given us a lot to talk about. Over the last few days, I've seen colleagues introduce articles of impeachment against federal judges because they don't like judges who actually stand up to these violations of the Constitution. And now we're seeing yet another plan to corrupt our judiciary take place. Let's go back, Mr. Chairman, to the nonpartisan agreement that was broken last Congress. We have no quarrel about the need for new judges. We all agree to it, but it's got to be done in a way that it's always been done. It's done for the next administration when nobody knows who it's going to help or who it's going to hurt. Madison said in Federalist 47, the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, whether hereditary, self-appointed, or elective, may be pronounced the very definition of tyranny. Let's avoid that. And I yield back to you, Mr. Chairman.
I thank the gentleman for summarizing. I will note that Monroe, Madison, Jefferson, and Washington were all Virginians, and so in that spirit, we'll go to the gentleman from Virginia, Mr. Klein, first.
Thank you, Mr. Chairman. And let's talk for a minute about the assault on an independent
I'm sorry.
judiciary.
I apologize. He has to leave, but he does not leave until you finish, Your Honor. With that, we go to our witness today, the Honorable Timothy. He has not. We gave our opening statement, sadly. The Honorable Timothy Timkovich has served as the 10th Circuit Court of Appeals judge since 2003, including for 2015 to 2022, his entire 7-year term. He has served as the senior judge. He has served as the chair of the Judicial Conference Committee on Judicial Resources, as a member of the Judicial Conference Workspace Conduct Work Group, the Cybersecurity Task Force, and has served on the Foreign Intelligence Surveillance Court review since 2023. We welcome the witness. I will mention to everyone that this is an open hearing. No FISA-related questions are possible. I say that just in the spirit of we all know what, we're not to touch it. And with that, Your Honor, thank you very much for being here. I look forward to your statement more than mine. You're recognized.
Chairman, Ranking Member Johnson, I appreciate the opportunity to sit here today and talk about this important bill. My name is Tim Timkovich. I'm a judge on the 10th Circuit Court of Appeals, appearing by designation of the Secretary of the Judicial Conference of the United States and on its behalf. Thank you for asking me to appear today to discuss the growing shortage of Article III judgeships and its harmful effect on the American public. I have previously served of the Judicial Conference's Committee on Judicial Resources, which has primary responsibility for our rigorous, independent process for evaluating judgeship needs. In that capacity, I've had the opportunity to previously testify before Congress in 2013 about the judiciary's judgeship needs. Since then, the problem has only gotten worse. Only a few short months ago, both the House and the Senate passed legislation to address our severe judgeship shortage in an overwhelming bipartisan manner. For the first time in decades, legislation was presented to the President that would correct severe stresses on the dockets of many courts throughout the country. Unfortunately, the previous administration vetoed the bill, publicly citing reasons that were not consistent with the record and reflect a misunderstanding of the facts. The shortage of judges is having a profound effect on the American public. Citizens rely on the efficient and timely administration of justice. But the shortage is causing significant delays for litigants seeking to resolve cases in the federal courts, especially civil cases such as copyright, trademark, patent, and contract disputes, which may take years to get to trial. Over the past 20 years, the number of civil cases pending more than 3 years rose 346%. In some of our country's busiest district courts, the time between filing and disposition for a civil trial is 4 or 5 years, compared to 20 years ago when the time was less than 22 months. Delays increase expenses for civil litigants and may increase the length of time criminal defendants are held pending trial. Substantial delays erode public confidence in the judicial process and the timely administration of justice. The problem is so severe that potential litigants may be avoiding federal court altogether, not having the resources or time to wait for their case to be heard or resolved. The problem cannot be addressed just by adding magistrate judges or hoping senior and visiting judges will lessen the workload and reduce the need for more judgeships. The judicial conference process for determining the workload needs of the courts already takes into account the substantial contribution that magistrate judges, senior judges, and visiting judges are making. It is the duty of the judicial conference to accurately, objectively, and fairly communicate to you the judgeship needs of the country. We have done so in the past, and I intend to do so again today in my testimony. I recognize that the long delay in addressing the country's judicial needs stem in part from the difficulty in resolving ever-evolving political dynamics and partisan concerns. But these political challenges are exclusively for the political branches to resolve. My duty here is again to put on the record that the judiciary has a severe shortfall in judgeships, which we hope you will fix as soon as you can. As Congress recognized last year in passing the Judges Act, the need is urgent and will benefit all Americans. My submitted written testimony covers 3 main topics. 1, outlining the implications of the judiciary lacking a sufficient number of judges. 2, explaining the rigorous, objective process by which the judicial conference determines those needs. And 3, enumerating the judgeship needs of the district and appellate courts. To summarize and conclude, the judicial conference has objectively determined the nation's federal courts urgently need 68 new judgeships. We continue to review those needs objectively, and we will keep Congress apprised of them. We urge you to quickly enact legislation that will address this serious problem. Thank you.
Thank you, Your Honor. As said before, I now recognize the gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. I appreciate you being here, Judge, and want to lend my support to your comments about the pressing need to address the problems that are existing in our judiciary, the backlogs, the need to fill these judgeships is so critical. And it was critical at the end of last year as well, when, what should be said clearly is an assault on the independent judiciary by the men and women on the other side of the aisle, by encouraging their president to veto this important bill. This could have been done, and these judgeships could have been filled, and the independent judiciary made that much stronger. But the other side decided to play politics, and it is unfortunate. But I also want to ask about the impact of the last administration's failure to enforce the laws of this country with regard to our border, the border crisis that was created by the last administration, encouraged by those on the other side of the aisle. And now, finally, we have a president who is addressing it. But in the meantime, in your testimony, you cite that the number of immigration appeals has increased from 145 to 611. Is that correct?
The gentleman will suspend for a moment and pause. Your Honor, if you don't mind, would you rise to take the oath? It was left out of the opening. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, to the best of your knowledge and belief?
I do.
Please be seated. Let the record reflect that His Honor answered in the affirmative.
All right. Thank you, Mr.
Clock may start again. Thank you.
That's all right. And I'm quoting your testimony back to you, so this should be an easy question. Is that correct, that the number of immigration appeals has increased from 145 to 611?
Yes.
And that the increases resulted primarily from appeals of decisions by the Board of Immigration Appeals, with the largest increase occurring in the Ninth Circuit. Is that correct?
That is correct.
I know we have several members from the Ninth on this committee, on both sides of the committee, who would like to see those judgeships filled. But you've noted how the civil caseload has increased substantially. How do immigration-related cases affect the overburdened federal judiciary? And how does the complexity of immigration cases contribute to the crisis of undermanned federal courts?
Well, thank you for the question. The immigration docket varies throughout the circuits. As noted, the Ninth Circuit has a particularly heavy number of immigration cases. I had the chance to recently be a visiting judge to the Ninth Circuit, and in my 2 days there, we had 3 immigration cases. So even at the circuit level, we're seeing a substantial number of cases, and that docket has been steady, it's been growing, and I don't see any reason that would discontinue.
And regarding the complexity of immigration cases?
They can be complex. It's an evolving area of the law. There's a number of issues that the Supreme Court's yet to address, but yes, they can be among the most complex given the types of record and the type of legal framework that's involved.
Do you think it would reduce federal courts' caseloads if all immigration-related cases were consolidated into a single federal court?
I haven't thought about that. It's an interesting concept. I'll take it back to the judicial conference as something that we might study.
I think that when you're looking at immigration cases, they can be complex, but they are also fairly consistent when you're talking about across the country, geography, not as factoring in less than the substance of the case. But so I would think that it might lend itself to some improvements there. But I appreciate you being here, appreciate your testimony, and with that, I'll yield back.
Would the gentleman yield? Your Honor, I've just one quick question while we're in between. My ranking member is also a member of the Transportation Committee. Could you briefly give us just so we get an understanding, the need to put these judgeships in over time related to the available courtrooms and so on. The facilities needed to add 60-plus members to the court.
I haven't had an opportunity to study that question. We work closely with the GSA in locating space for judges, whether in courthouses that have available space or nearby private facilities. So that's part of the process we go in locating new judges, even when we have...
But the process doesn't begin until we authorize the judges, is that correct, effectively?
That's correct.
And being a Californian and a San Diegan where we have leased space and a complex situation, isn't it true that that's one of the inefficiencies of the court right now, that we're finding that we're leasing space and that means you have security in 2 locations, a lot of facility-related ones that don't begin until we assure you that what your number is going to be in the future?
Yeah, we have a Space and Facilities Commission, a committee that addresses those types of concerns, and I'm sure that they'll take a look at the question that you've presented.
With that, my ranking member, who serves on both committees, Mr. Johnson.
Thank you, Mr. Chairman. I would note that across the country there are courthouses with vacant courtrooms ready to receive newly authorized judgeships and judges, like in the Northern District of Georgia, for instance, where under the legislation that is about to be filed, I think we get 2 of the 4 that we really need in the Northern District of Georgia, but we have room for at least 3 district court judgeships in the Richard B. Russell Federal Building back there. Mm-hmm. And I'm sure that there are other courthouses across the country that can accommodate and need new judges and judgeships. But for my colleague who had to depart, who was so much interested in immigration cases, he didn't ask you about the 20 immigration court judges that Trump and Musk just summarily dismissed last week. But nonetheless, Judge Timkovich, I thank you for being here today. Since he took office, Donald Trump has shown open contempt for our Constitution, the rule of law, and for the independence of our federal court system. So I have a hard time understanding how we are supposed to sit here and cordially talk about giving this man more federal judges to appoint. The blatant disregard, the constitutionally based doctrine of the separation of powers by the Trump-Musk administration is the crisis that we should all be talking about, because it's not a matter of if Trump will challenge the court's authority, it's a matter of when and how far he will go. So again, thank you, Judge Timkovich, for agreeing to appear before us. I read your testimony and I agree that we need more judgeships. I've been sensitive to that need for many years. But our judiciary is only as good as the independence of the judges we appoint, and I cannot in good conscience advocate in favor of allowing this president to appoint individuals who have sworn fealty to him over our Constitution. Our Constitution's twin principles of separation of powers and checks and balances has worked in tandem for the last 250 years to ensure that our Constitution secures Americans' rights to impartial justice. Our nation's rule of law is grounded in the independence and impartiality of our courts and their power to say what the law is. Judge Timkovich, based on your years of experience, are you aware of any instance in which a president of the United States willfully disobeyed or resisted a lawful writ, process, order, rule, decree, or command of a federal court?
I'm here to talk about the urgent need of the judiciary for additional judge.
Well, I understand
It wouldn't be
that.
appropriate for me to comment on any pending cases.
Well, I understand, but I've been around for 70 years, 50 of which, or 45 of which has been as a lawyer, and I've never known of a president to willfully refuse to comply with a court order, but I see it coming. Now, should that happen, a judge would theoretically be able to hold a president in contempt of court. Isn't that correct?
We have our principles of separation of powers and longstanding rules in case law that addresses that, yes.
Yeah, and if a president willfully failed or refused to comply with a court ruling, they could be held in contempt of court theoretically, but it would be up to the U.S. Marshals Service, which is a part of the Justice Department, to be the enforcement arm for the federal courts. Is that correct?
Your hypothetical would have to play itself out.
It would be the U.S. Marshals who fall under the Department of Justice who would have to carry out the contempt order. And so what would happen if the U.S. Marshals Service, under the command of the Justice Department at the direction of the President, refused to carry out a court order of contempt? What would then be the state of our democracy?
Again, I'm here on behalf of the Judicial Conference to talk about the shortage of judges that we have, and I would comment on those needs in particular.
Well, the American people would love to have heard your response to those questions, but they will get those responses from many commentators who are pondering that question and what it would mean for our democracy should that take place. And with that, I yield back.
I thank the gentleman, and I can't answer that question for sure either, but I will say that famously Teddy Roosevelt said he was going to send the Great White Fleet around the world, and Congress said that they couldn't afford it. And he said, great, I'm going to send them anywhere I want to, and you can pay to get them back. This is not the first time we've had a challenge, but I will research that other one too. We now recognize the gentleman from Wisconsin for his questioning, Mr. Fitzgerald.
Thank you, Mr. Chairman, and thank you, Your Honor, for being here today. I wanted to just ask about a specific judge, and I think the reason I'm trying to frame it up this way because it might give you an opportunity to just give us more information about a process, obviously. So for nearly the past 2 years, Judge Pauline Newman, a Reagan appointee, has been suspended from active service given conflicting allegations about her competency. While she's in her 90s, obviously that itself is probably having an effect on him, but is not the issue, nor certainly a basis for what has been called the stealth, quote-unquote, stealth impeachment. So given her apparent indefinite suspension, the court is operating with what is considered an unmanned seat. And you can be as specific, I guess, as you want, or as general as you can be. But accordingly, access to judges for entrepreneurs, veterans, and others, they seem to be kind of hindered. And I wonder if justice delayed is not justice denied. So can you comment on whether a federal court can hear cases en banc when a judge is in the suspension penalty box, I guess is maybe the way to refer to it as, which is certainly the case right now with Judge Newman?
Yeah, I cannot comment on that. It's a pending matter before that court, and its particular rules would govern participation in judicial proceedings.
Do you have any idea kind of how widespread this is, where we've got judges in place that are not performing on a daily basis the requirements of what typically you would expect a sitting judge to do?
I'm not aware.
Okay, okay. Chairman Issa and I have introduced legislation requiring disclosure of certain third-party litigation funding arrangements in federal courts. In October 2024, the Judicial Conference agreed to create a subcommittee to study whether the conference should propose a federal rule requiring the disclosure of third-party litigation funding, otherwise known as TPLF. Judge, do you have any idea, can you give us any summary or background on where you think that subcommittee is, and is that something that eventually we could expect a decision from the subcommittee specifically?
Yeah, I wasn't briefed on that as a part of my testimony this morning. However, I'm quite confident the conference is doing as it's represented to the House, and it's studying the issue under the appropriate committee of the Judicial Conference.
So has the committee, do they have a, I don't want to say predisposed, but do they have any kind of position right now on the way they feel about what's currently happening under the guise of kind of that effort?
Yeah, not to my knowledge.
Okay, very good. Thank you. I yield back.
Gentlemen, yield.
I do yield,
You
Chairman.
know, the ranking member and I were just going over the history, and so perhaps I won't ask the judge, but I want to put into the record that under the last administration, I think His Honor is aware that the U.S. Supreme Court ruled that President Biden could not, in fact, forgive student loans. But in fact, after that ruling, the president said, well, I'm going to find another way, and I'm going to effectively do the same thing, and he did. And it did not get back to the Supreme Court before he left office. But it does appear to this member as though the president, given a clear understanding that it was Congress's ability to appropriate money or to forgive substantial money across the board, made a ruling, and that those dollars currently that were forgiven were in clear violation of the court's intent. Whether or not the president would have eventually succeeded in circumventing the court is a different question. Secondly, the law, the statute, that a number of statutes that President Biden used to, on a wholesale basis, allow 10 million plus people to enter the country, repeatedly were ruled not to be right according to the court, but till his last day, the border remained open. So I might say that constitutional challenges do get resolved at the U.S. Supreme Court to the extent that the U.S. Supreme Court comes back again and again and again, if necessary, against an intransigent president like the last one. And with that, it is my pleasure to recognize the gentleman from Maryland, the ranking member of the full committee, for his 5 minutes.
Thank you, Mr. Chairman, and forgive me for a quick digression, Judge. The case having to do with college student loans was decided on statutory grounds by the Supreme Court, saying that the president lacked statutory authority to forgive the student loans, and then that was the invitation taken by President Biden to find another statutory mechanism by which to do it. It was not a constitutional decision, but I'm happy to order up a copy of the case so we can look at it.
No, when I said it, I said that, ultimately the firing people is a statutory decision, not a constitutional decision. The question of the gentleman from Georgia was about,
clock is
would you
running.
defy that?
All right, I don't want to devour all my time here, but a statutory firing can be unconstitutional if due process is denied where it's based on political discrimination or retaliation, and the Supreme Court has repeatedly found that, as in Connick versus Myers and a whole string of authority. But so, Judge Timkovich, let me just start with you for a second. Can you've written eloquently about the Republican Guarantee Clause and about Marbury versus Madison in there. Would you mind just stating for the committee the importance of getting new judges based on what judicial review is? What is judicial review, and why is it important to have new judges?
Yeah, thank you for the question. It really is kind of foundational to the request that we're making in supporting this type of bill. As was indicated, there's been no substantial increase in federal judges since 1990. Since then, our caseloads increased by 37%, yet we've only had a handful of judges that were
I got you, Your Honor. I guess, would you help us explain to America why it's important to have federal judges on the bench? Because some people say, well, that's just, another person, sitting around with a bunch of law clerks not doing anything. Why is it of fundamental constitutional importance for us to have judges on the bench?
Well, of course, the judiciary is the third branch of government established by the Constitution in tandem with the first Article 1, the legislative branch, Article 2, the executive branch, and Article 3, the judicial branch, the Republican form of government, the Guarantee Clause, guarantees that we have a Republican form of government that includes elected officials and subject to the legislative process, subject to the judicial process when cases are brought.
All right, so
and the
let me
like.
give you an example. So we've got more than 75 cases now that have been brought in federal courts against the new administration for illegally seizing money, impounding the money that Congress has appropriated for particular purposes, for illegally firing workers who have protections under civil service, not to be fired for political or for arbitrary reasons. And there have been more than 20 temporary restraining orders and preliminary injunctions issued in these cases in order to vindicate the Constitution under judicial review. Now, say we didn't have half of those judges, would that be less justice that would be done right now?
Well, certainly we need additional judges to address additional work, and whether it's as a result of the types of challenges you were mentioning, or I think more importantly for the American people is just the day-to-day cases where they have the inability to get a timely resolution of the case. And this bill,
Well,
to the
these are
extent it's
day-to-day
envisioned, would help
cases
address
now,
that.
as you know, at least here in Washington. These are day-to-day cases. I mean, the January 6 cases, which were dominating the docket around here, are gone after Donald Trump's pardon of more than 1,500 insurrectionists, including violent criminal felons who beat police officers in the face with Confederate battle flags and pipes and broken furniture. But now what's taken over is these cases where workers are trying to go and vindicate their rights from NIH or FDA or NOAA, the FBI. There were federal prosecutors who were fired simply for having participated in the January 6 cases. And I know that most judges would think that that is deeply problematic, that prosecutors are being fired simply for doing their job. If we don't have the judges to deal with this, would we be in a dangerous situation with respect to an executive branch cannibalizing all parts of the government?
Well, we believe the need for new judges is urgent and necessary now. And
Well, I agree with you about that, and I thank you for your testimony and for your hard work.
thank you.
I thank the gentleman. And with that, we go to the gentleman from California, Mr. Kiley, for 5 minutes.
Thank you, Mr. Chair. I am a co-sponsor of the Judges Act, your legislation, which we worked very hard to get passed last year, which passed the Senate and the House with overwhelming bipartisan support. But unfortunately, it was vetoed by former President Biden. I condemn the former president's veto in the strongest terms. This was done for one reason and one reason alone, because he lost. Is there any doubt at all that if former Vice President Harris had won the election, that President Biden would have signed that legislation? And the way that it was crafted was in order to try to shield the bill from these sort of crass political calculations, from the pettiness and rank partisanship that ultimately dictated former President Biden's decision. It was crafted and passed from behind a veil of ignorance. The Senate passed it overwhelmingly in August of last year before we knew who the winner of the presidential election would be. Not only that, but the appointment of judges was phased in so it wouldn't just be the next president or now the current president who would get to make all of the appointments. And so, I get asked a lot at town hall meetings, at other gatherings from constituents, how do we overcome the political division in this country? Why do things keep getting worse and worse? And this is just a perfect example where you had a president who defied the bipartisan will of Congress, who defied the recommendation of the Judicial Conference simply because he was upset with the outcome of an election and didn't want to cede any advantage to his political opponents. I think it's absolutely disgraceful. And the reality is that we have caseloads in every circuit in this country that have become a serious problem. At this point, there are 210,800 cases, civil cases, that have been pending for more than 3 years. I'll say that again. The The number of cases that have been pending for more than 3 years is over 210,000, and of course, there are many that have been pending for much longer. Now, it should be acknowledged that some of this represents the propensity for frivolous litigation across many different areas of law. But it also reflects the fact that we have not, in a significant way, authorized new judges since 1990. And so what's the consequence of that when we have this sort of limited access to justice? Well, imagine if we had a judiciary that existed on paper, but we had no judges at all. At that point, we'd have a constitution, citizens would have rights, but there'd be no means of vindicating them, no means of enforcing them, so they'd be essentially meaningless. Well, that same problem exists to a commensurate degree if we have an inadequately staffed judiciary. If we have citizens who have to wait years and years and years in order to have their cases resolved and heard. And when you have these cases tied up for so long, this is just an enormous deadweight loss in our economy. Protracted litigation doesn't result in any sort of increased productivity or anything like that. It's just sheer loss. And what's more, it particularly disadvantages smaller litigants. Let's say a startup trying to defend its intellectual property. While this case is going on for years and years and years, they're not able to market their product, they lose market share, they're not able to get investors, the company might die. And in fact, some larger litigants explicitly use that as a strategy in order to prevail in their cases. So it's worth asking, why is this the case? Why has the rest of government continued to grow and grow and grow, but we haven't been able to keep up with the number of judges we need? And I would surmise that perhaps it's because judges don't have high-powered lobbyists who are able to go around, aren't able to mobilize powerful interests on their behalf in order to expand their ranks in the same way that you have for other areas of government. But maybe I'd ask you that question, Judge Timkovich. Why do you think this has become sort of a persistent problem where we're not able to maintain the number of judges that we need? And do you see any solutions to it that would help us overcome some of the political barriers?
Well, like I said, I testified on this very issue 10 years ago, and the problem was grave then, and it's only gotten worse over the last decade. Last year, a bill did get through both houses of Congress. So to the extent the process works with what you up there do, not what we do, we're hopeful that there can be an opportunity to solve the problem on the judiciary. We currently have 20 judicial emergencies around the country. They're not located in one district or another. The bill that was proposed involves 25 different courts, district courts, over 15 different states across the country. So there's widespread need for the bill, and there's widespread opportunity for members of Congress to address needs within their local communities as well.
Thank you. I yield back.
Gentleman yields back. We now go to the gentlelady from California, Ms. Lofgren.
Well, thank you very much, Mr. Chairman, and thank you, Judge, for being here. It's not often that we get a chance to talk to a judge in these chambers, and it's very much appreciated. And the fact that you were served on the FISA court, I think, is emblematic of the respect you are held by your colleagues in the judiciary, so I appreciate that. In addition to the workload issue that you've raised, I think it's very important that we guard the integrity and independence of the judicial branch. Last year, the Ninth Circuit Judicial Council referred former Judge Joshua Kindred to the House for impeachment due to serious misconduct, a hostile work environment, inappropriate relationships with law clerks, false statements, and the like. This was extraordinary. Since 1804, only 15 federal judges have been impeached. And as you know, the constitutional standard for impeaching a federal judge is high, as established by Article 2, Section 4's requirement of high crimes and misdemeanors, which some interpret in conjunction with the Article 3, Section 1 standard of good behavior. Judge, to your knowledge, has the Judicial Conference ever referred a judge for impeachment simply because of a disagreement over a ruling?
Representative, I'm not aware of the judicial conference or its committee on judicial conduct and disability in every instance. So I'm reluctant to answer that because I don't know, but I'll get back to you with a response after the conclusion of the hearing.
Well, I appreciate that. I'll just note that, in fact, to date, there is no known instance of the judicial conference referring a judge for impeachment based on a ruling. Every referral has been based on serious misconduct allegations, bribery, perjury, corruption, not legal decisions. Would you think it would be all right for the Congress to impeach a judge because they didn't like the decision he or she made?
Well, I'm going to defer to Congress. The House and the Senate have the sole authority over the impeachment clause, and I think it's a part of the political process that would not be appropriate for me to comment on.
Well, I'd just like to note that just last week, one of my colleagues on the other side of the aisle filed an impeachment resolution against Judge Paul Engelmeyer, not for misconduct, but because of a ruling they disagreed with, and then days later, Representative Van Orden posted this on X, quote, "The American people gave at real Donald Trump a mandate, and no politician disguised as a jurist will interfere with it." And then over the weekend, Elon Musk demanded that Judge Abelson's impeachment after he blocked an executive order on DEI. And Musk has also urged Congress to purge judges who rule against Trump. So I'd just like to note that not only would it be improper and unconstitutional to impeach judges because of their decisions, the proper response is to appeal those decisions, but it has potentially the impact of intimidating judges who should be completely independent. And I will note that for the most part, the judiciary here in America has made their rulings, doesn't matter who appointed them, based on the facts and the law, and that's just what we need in the third branch. I'll just say one other thing on the immigration issue. For years and years, Judge Mary Schroeder and I worked together trying to come up with a solution to the appeals problem in the Ninth Circuit, but also elsewhere. And it's not just the number of judges, but how we structure that whole system. I would recommend that you take a look at a bill I introduced called Real Courts, Rule of Law, that would help clear up the procedures to relieve the burden on the judiciary. The Federal Bar Association told me it was one of, if not their top priority in terms of legislation. I wouldn't ask you to comment on today, but I would recommend that you take a look at it. I'll just say that in my 50 years as a member of the bar, I've never seen the kind of attacks that we're seeing today on the independence of the judiciary, and I find it very troubling indeed. And with that, Mr. Chairman, I yield back.
The gentlelady yields back. We now recognize the gentleman from Kentucky, Mr. Massey.
Mr. Chairman, I'd like to yield my time to the chairman.
I thank the gentleman. Your Honor, I won't ask you to comment on maybe the former majority leader in the Senate's threat against the court. So even though I have seen those sort of things, I will ask you to opine on one thing that is slightly outside of today's hearing, but I think it's well within your jurisdiction or your history and knowledge, and that is one of the bills that is being considered as part of today's hearing is H.R. 1526, the No Rogue Ruling Act, which would limit the decision power when made outside the D.C. Circuit. In your history of seeing things which affect Washington, D.C. and the executive branch that are filed all over the country, as the over 100 cases, only 9 have been filed in the D.C. Circuit. Not from a what's right or wrong, but from an efficiency standpoint, from a quickness and accuracy, is it in fact appropriate that national prohibitions on the executive branch most appropriately be brought historically to the D.C. Circuit for handling?
Mr. Chairman, I don't have the authority to comment on that on behalf of the Judicial Conference. Obviously,
As an appellate judge, what have you seen?
well, as an appellate judge, we do hear cases from administrative agencies throughout the circuits, but it's a more limited jurisdiction. I think the conference would be happy to study the details of the proposed legislation and then comment when appropriate when they understand what exactly the legislation is intended to.
I appreciate that. In your viewing of history, though, isn't it true that most commonly a decision by a district court judge or even the appellate court in one circuit is not binding on others, but in fact, that's what the Supreme Court does, is find ambiguity between multiple circuits and settle it once and for all. That's essentially the history of 200-plus years.
Yeah, that's correct.
Okay, we'll just leave it as we have a long history, and that's not what's happening in these national prohibitions. Back to the court, and I agree with you that impeachment is a political decision, and so the Judicial Conference weighing in and recommending a political solution is not, is not likely to be anything. Although in your histories looking at that, the Judicial Conference does in fact review the conduct of judges and does offer a path to disciplining and or disapproving of actions of judges in addition to their chief judge in each circuit. Isn't that true?
That's correct.
And during your time, there have been a number of efforts by both this Supreme Court Chief Justice and others to strengthen that capability. Is that true?
You'd have to give me some more specifics.
Justice Roberts has done things that others haven't. For example, a form of admonishment of districts in Texas that were grabbing cases and holding them tight such that they had a substantial portion of the entire nation's. You saw Chief Justice Roberts weigh in a way to curtail that activity. In other words, in your history, there is some significant self-regulating or self-looking over the shoulder of your colleagues. Even though you're equals, there is some group effort to find and hold members who are outside of the bands of normal behavior.
That's correct.
Okay, I just want to make sure that we put that in the record, because I think sometimes we look at the exceptions rather than the rule. I will say that when I look at the other branches of government, we should all hope we regulate ourselves as well as the judicial branch. Back to the bill at hand. In your estimation, will these 66, 67 judges, both temporary and permanent, depending upon how we do it, will they in fact catch us up to where we were 20 years ago?
It is a substantial and significant improvement from where we were. It has been a long, long time since we've had help in the judiciary. And
my time is expiring, but I just want a yes or no.
Yeah,
will we in fact have larger caseloads even after we implement these than you had 20 years ago?
yeah, based on our report and survey, this would do a substantial improvement of where we are now. Thank you.
Thank you. And we now go to the gentlelady from North Carolina, Ms. Ross.
Thank you, Mr. Chairman, and thank you to our witness for being with us today. This is a very important hearing on judicial vacancies, and I want to discuss the very real and urgent need for additional federal judges, one that directly affects the people of North Carolina. In the Eastern District of North Carolina, we now have 2 members on this committee from the Eastern District of North Carolina. We have thousands of Camp Lejeune veterans and their families awaiting justice. These are men and women who served our country honorably, only to suffer from devastating illnesses caused by toxic water contamination. Their cases are backlogged in an overburdened court system that simply does not have the resources to deliver timely justice. It's unconscionable that these families have already endured so much, and must wait even longer because there simply aren't enough judges in the Eastern District to hear their cases. Addressing this backlog should be our focus, and we will have a bill to do just that. It should be a priority of this committee and every member who claims to care about justice for our veterans. But let's be honest, that is not why we're here today. If this committee was serious about addressing judicial shortages in an impartial manner, we would have passed the Judges Act last Congress well before the last election, giving the first set of judgeships to an unknown president. So today's hearing isn't about solving the real problem facing our judicial system. It's about installing judges who will serve an agenda rather than uphold the law. My Republican colleagues, many of whom I have great respect for, Mr. Chairman, refused to act early on, and we even discussed this early on when a bipartisan solution was on the table and we could already have more judges. But alas, we have American families, veterans, and businesses who have been waiting. So now I'll turn to my questions. Judge Timkovich, even though the judiciary is an independent branch of government, you've relied on both the legislative and the executive branch for certain functions. For example, the judiciary receives most of its federal funding through appropriations from Congress. Is that correct?
Correct.
And for fiscal year 2025, the judiciary requested an increase of $39.5 million in funding for the court security account because these funds are necessary to address significant increases in threats against federal judges. Can you describe these increased threats and the types of services funded by this account?
Thank you for the question. I would refer it to our Judicial Security Committee, which I'm not a part of, so I can only comment to a large extent that there have been appropriations by Congress that have allowed for increased judicial security over the last 5 years or so, and we appreciate that.
Yes, so in fact, there were 457 cases in 2023, and they doubled. And the Marshal Service provided that information. And the Marshal Service is particularly responsible for providing this security and executing court orders. Isn't that correct?
Yes.
And are you aware that one of their duties is investigating these threats against federal judges?
I think that's correct, yes.
And they use the Judicial Security Fund in order to provide that kind of security, correct?
Yes.
So what is the risk to judges if the Marshal Service failed to provide this kind of security?
If they fail to provide that type of security, well, it's a context-specific question, but it's an important part of the overall security of the federal judiciary.
So removing the security, which could happen under this administration because they've been removing security from a former president, people who worked in the military, could threaten the safety and the independence of our judicial system. Would you agree with that?
I'm not aware of any current reductions, but we continue to support adequate funding for the judicial security.
Well, I appreciate that. I hope that you will support having the Marshal Service execute its duty to the judiciary despite any pressure from the executive branch. Thank you, Mr. Chairman, and I yield back.
I thank the gentlelady. We now recognize the gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman, and welcome, Judge Timkovich. Thank you for joining us today. During your opening statement, you referenced the Bipartisan Judges Act and the veto and message associated therewith from the White House, and indicated that it was not reflective of reality and evinced a misunderstanding of the facts. I agree completely and believe that is such an important part of this hearing today. First, it's also important to note that the suggestion that that act was partisan is not rooted in facts. It was a bipartisan bill that would have not only added additional Article III judges, it would have staged the addition of those judges so that they crossed multiple administrations. So it was an unnecessary and an unwarranted veto that has exacerbated the burden on the courts and continued to inhibit access to justice. I come from the Middle District of Florida, where, as I'm sure you know, is one of the most populous and the busiest districts anywhere in the United States of America. Whether we go by weighted caseloads or unweighted, it is an incredibly busy district. I had the privilege early in my career of serving as a judicial law clerk to one of our Article III judges. Later, as an AFPD and an AUSA, I spent much of my career inside the walls of the Tampa Federal Courthouse and can attest firsthand as to just how diligent and hardworking those judges, the magistrates, and everyone else in that courthouse is, and how vital it is that we properly fund our courts as a co-equal, independent branch of government that needs to be properly staffed and funded to do its job. You mentioned something else in your opening that I want to go back to, and that is the concept of speedy trial. For those who are not criminal practitioners, would you please elaborate for us, Your Honor, on the distinction between civil and criminal cases? What happens if criminal defendants do invoke their right to a speedy trial? What then happens to a judge's civil docket, and how does that affect access to courts?
Well, as you know, as a former law clerk, the criminal cases take precedent over the civil cases. A defendant in our system of justice is entitled to statutory protections that ensure that the trial occurs on a speedy basis. The Constitution also has a due process guarantee that requires judges to expedite those cases within timelines set either by statute or by case law. So if we have an inadequate number of judges in district courts with particularly heavy criminal dockets, presumably the Middle District of Florida, which I see it would be eligible for several new judgeships, it can put a lot of pressure on the rest of the civil docket if those criminal cases are taking over the time that's necessary to try them.
That's exactly, I think, something that's very important to understand. So when that happens, then civil litigants, individuals and businesses that have disputes that need resolution in the courts, their cases will get delayed. Another thing that you touched on is the concept that when that happens, when those delays are too pronounced, when they're too long, that can have a chilling effect on people coming to court or electing to use a trial as a potential resolution for their dispute. Would you share with us a little bit more about your view on why it's important that Americans who have a dispute, that want it resolved, that would like to go to trial, have the ability to utilize our courts efficiently and effectively to do that?
Yeah, every dispute in this country should be resolved quickly, fairly, and efficiently. And the current status of the federal courts, because of our judgeship needs, is compromising the ability of those types of cases and those types of litigants to have their day in court. And without getting their day in court, we think that erodes trust in the judiciary, faith in our system. And to the extent we have an adequate number of judges to maintain and move our dockets, everybody benefits from that.
Unless I noted in your introduction today that you take on a number of special responsibilities within the Judicial Conference, and I know many of your colleagues also do this. So we're here today, we're talking with one of the easiest to access data points, which is the overwhelming number of cases that are assigned to every judge across America. Tell me why those extra responsibilities, judges who are willing to teach, to take on the FISA court, to work on cybersecurity, why are those important, and how does that add to the workload of a judge who's really performing their job very well?
It's an important question, and it's also equally important to note that the survey results, the methodology that we use to estimate the number of judgeships that are needed is not based on those extra duties. So the numbers that you get for the basis for this legislation are purely based on what the court is doing deciding cases. And most of our judges do extracurricular activities, teaching, going out into the community, serving on judicial conference committees like I am. And those are all important functions for the judges, and I think it's important for the public at large. But we don't get credit for those for purposes of this judgeship bill. So just note that that's in addition to what the basis for this request is.
Thank you, Mr. Chairman. I'm out of time.
Thank you. I now recognize my colleague from California and note that we as Californians are recipients of 6 out of the 21 judgeships that would be granted in the next 4 years. Mr. Swalwell is recognized.
Thank you, Mr. Issa. Thank you, Your Honor, for appearing today. As you know, and you've practiced in many different courts and areas and jurisdictions, a local U.S. attorney working with the Federal Bureau of Investigation, if they want to bring or proceed in an investigation, at some point, court supervision becomes involved, meaning that an FBI agent can talk to witnesses, they can subpoena metadata phone records without going to the courts, but if they want a search warrant, or if they want to do a wiretap, or impanel a grand jury, at some point the courts become involved. What do you believe the role of the court should be as an independent branch when the U.S. Attorney's Office brings a criminal investigation that warrants their involvement?
Well, again, that's somewhat out the scope of my testimony this morning on our judgeship needs, but the criminal process is well developed. And I didn't personally practice as a criminal lawyer before I came on the bench, but that's a large part of my docket now. And the system is quite developed as far as grand jury paneling and subpoenaing records and the like. So it's an ordinary and common part of our practice. And to the extent we have heavy criminal dockets in some of the courts that are underserved, it's going to compromise the efficiency and the speed with which those types of criminal investigations can take place.
And if the court is routinely rejecting search warrant applications or evidence to impanel a grand jury, do you believe the court has an obligation to, or like a duty to report to the public that there is not just an insufficiency in evidence in a particular case or cases, but that the government continues to fail to meet its burden? And I guess I'm just asking if, once the courts get involved, if the courts don't see the evidence there and the government routinely is coming back to the court knows that the government doesn't have the goods to proceed, but the public does not know. And at some point, if the government seems to be abusing its power, what is the mechanism for the public to know besides the court just saying no and the case not being able to proceed?
Yeah, I haven't studied that issue, and grand jury secrecy is an important part of the system, and we can certainly I can go back to my colleagues and take a look at that. I don't know if it's been studied yet, but it might be worth taking a look at.
Thank you. And Your Honor, you agree that the U.S. Marshals, all 94 of them who are appointed by the President and confirmed by the Senate, can also unilaterally be removed by the President?
I'm sorry, could you repeat the question?
That a U.S. Marshal may also be removed by the President.
I'm not familiar with the management of the Marshal Service to that degree.
Are you familiar, though, that recently in the D.C. District Court that U.S. Marshals were intervening and directing judges to expedite the release of January 6 inmates whose cases had been pardoned?
I'm not familiar with that.
What would you think of having an independent protection agency for judges that is outside the appointment of the President? Meaning a judge's security is dependent in many ways on the Marshal Service, who the President appoints to protect the judges. And if a president doesn't like a decision that's coming from a judge, theoretically they could pull their security. We've seen this with this administration where former Secretary of State Pompeo and National Security Advisor John Bolton had their security details recently polled by the president, and it was seen as being done in a punitive way. Do you think you could better protect judges if your security was more independent, similar to the structure we have here with the Capitol Police and its oversight?
Yeah, I haven't studied that. It'd be appropriate for our Judicial Security Committee to take a look at that and evaluate whether that makes sense for the federal judiciary.
Great. Thank you.
Would the gentleman yield?
Yes.
Your Honor, we know you're from Colorado and you're representing today, but if you don't mind, we'll make it part of the record, and Mr. Swalwell and I will forward that question. But if you don't mind making sure that that is a question that legitimately this subcommittee would have of, we've granted additional security recently after attacks on members of the court, and you as a FISA judge recognize the additional threat. But the question of, should we look at a makeup that is more under the control of your branch, I think is a legitimate question that I hadn't heard before, and Mr. Swalwell and I find opportunities to agree on questions. So if you don't mind taking that back, I know you have someone behind you that I know very well will take it back. So that's why I thought I'd make the point that it's truly bipartisan question.
We will, thank you.
Great.
Thank you.
Great. Thank you. Yield back.
We now go to the gentleman from South Carolina, Mr. Fry, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Judge, for being here. I think it's remarkable. I mean, we heard this last year on the Judges Act and how short you were on personnel to adjudicate cases. I think this, as part of our jurisdiction, is an important dialogue to have. Judge, during the 118th, the Senate unanimously passed, as you testified to, the Judges Act. After the election, though, the bill lost a lot of, in fact, all bipartisan support, most bipartisan support, with only 29, I think, Democrats voting in favor. Although the bill passed both chambers, President Biden, who previously was supportive of it, vetoed it. Judge, do you believe that, that the Judges Act was an appropriate solution to address our nation's judicial shortage?
Yes, I do.
In your opening remarks, you referred to the Statement of Administration Policy, SAP, on the Judges Act. SAP criticized the bill for, quote, hastily adding judges. But you countered this claim, stating the legislation was not hastily drawn up, but was the product of years of study, analysis, and congressional review. Does this mean that you disagree with the prior administration's assessment? And if so, can you expand on why?
Well, the Judicial Conference certainly stands by the recommendation that we, for developing new judgeships. It's a very rigorous, objective, and honest process. We evaluate thousands of cases to evaluate whether a particular district needs a new judgeship. We look at special factors like the contributions of senior judges, magistrate judges. So the process that we go through is very rigorous, very objective, and a lot of math in there. The committee that looks at this issue is called our Subcommittee on Statistics. So you have to know a little bit about math to understand that. But it's a very rigorous, objective process. And it is not, like I said in my testimony, we've been presenting these types of surveys for 30 years. I've been heavily involved with it over the last 15 years, and I'm really confident that our process is well designed to address the vacancy needs of the federal judiciary.
Well, knowing that, and obviously this sounds like it took years, it was a year-long or multiple year-long process. That information was readily supplied to the administration, I'm sure, on y'all's behalf. Is that correct?
I believe so.
Okay. And so what insight do you have on why former President Biden chose to veto this bill, given your work on this issue?
I don't have any view on that.
Well, I mean, I think it's pretty patently obvious that it would be partisan politics, partisan motivations given. Now, do you think that may have changed if Kamala Harris had won the presidency, that he would have not vetoed that legislation?
I don't know. That's a question for the administration.
Okay. All right. Well, I think we can all read between the lines here. As President was previously supportive of this, Democrats were certainly supportive of it, and then they weren't within the same Congress. We'll move to injunctive relief in my brief time here. Judge, What is a preliminary injunction, and how does it differ from a TRO? Just from a legal standpoint.
Were you taking me back to law school?
Let's do it.
Well, a temporary restraining order is an emergency order that maintains the status quo during the pendency of a case. Preliminary injunction is an injunction that stays a proceeding through a trial on the merits. Generally, there's many deviations and variations to that statement.
What is the standard for a preliminary injunction?
It requires some type of emergency relief, extraordinary circumstances by a party that would be concretely harmed.
What about a TRO?
Similar.
What is a nationwide injunction, and how does it differ from a normal, ordinary preliminary injunction?
Well, it's a little outside the scope of my testimony on judgeships. Injunctions generally bind the parties that are before the court. Nationwide injunctions have broader scope.
And what about, what is the legal authority that would be relied upon for issuing a nationwide injunction?
It depends on the presentation of the parties, so there's really no fixed lodestar to that.
So it's up to the discretion of an individual judge?
It's generally discretionary,
Okay.
subject to circuit review and Supreme Court review.
Okay. What is your assessment of the common law around it, that it is entirely up to the judicial?
I'm sorry, the what?
The common law aspect of this, is it entirely up to the individual judge to make that determination on whether they issue a very narrow or a very broad nationwide injunction?
There are actually guardrails within probably each circuit's case law on the scope of injunctions.
Thank you, Mr. Chairman. I see my time has expired, and I yield back.
I now recognize Mr. Hunt. Mr. Gooden, for 5 minutes. Yield to me.
Yield my time to Mr. Issa.
Thank you. I thank the gentleman. And as we're getting a little closer to the end, there's a little bit of back and forth, but I want to make sure we make the record clear on a number of areas. And one of them is that we have noticed the Litigation Transparency Act, and I know that's, again, outside the specifics of what you came prepared for. But I do want to ask you a couple of quick questions. Are you familiar with the Delaware case in which a litigant was ordered to disclose the economic beneficiary of litigation?
I'm not aware of that case, Mr. Chairman.
Okay. Have you had cases in which the litigant was acting on behalf of other funders, to your explanation, that you didn't know about?
Not to my knowledge.
Have you ever had a case in which there were third-party funders of litigation?
I'm not sure I would know that on a particular case.
Okay. As a federal judge, and I go to the old school that, you know, the difference between God and a federal judge is God knows he's not a federal judge. I know it always gets a laugh, especially from those on the bench. But if you had a case and you chose to ask for disclosure of who the funders of the litigation were on the plaintiff's side, and of course on the defendant's side, and if, as is the case, it is normal discovery and disclosure in the case of the defendant about whether they have insurance or some other mechanism to pay the damages, would you say that was within your current authority to balance, to ask?
I haven't studied our rules that govern disclosure or party disclosure. We do have those within the rules of civil procedure or jurisdiction, and I'm not actually familiar with what the scope might be as it pertains to your question.
Well, the scope, in a sense, is this. Currently, if you're the defendant, let's say in a patent case, or any case, the plaintiff asks for and demands and gets a disclosure of whether you're insured. In other words, how deep your pockets are. The plaintiff also gets your balance sheet, your profits, and all kinds of other information germane to whether or not you can pay if you lose. And they get that normally prior to winning the case. Isn't that true? As part of discovery.
I think it might be as part of discovery.
So the Litigation Transparency Act simply says that the judge has not a demand, but a right and a full expectation that they may ask for and get disclosure as to who the beneficiaries or the financiers are of the plaintiff. In other words, both sides get to look into each other's pockets about how deep it is. Does that seem unreasonable to you as a man holding that, wearing the blindfold and holding the scale?
I think it's a policy question that Congress, can address and give us direction.
Thank you. That's exactly the answer I needed to make my day. Back to the situation at hand. And this is not a hypothetical question because it's a real question that we may have to deal with in finding a way to carve law, this Congress related to this. If you had a choice of waiting 4 years or getting your judges in an order that is not ideal, but in fact allows you to have judges somewhere among the 60-some judges sooner. In other words, if in the first 4 years you got judges that were not previously in the order of implied shortage and importance, would that be better than not having judges?
Yeah, the position of the judicial conference is that we need the judges urgently now, as soon as we can get them, in whatever format we can get them, and whatever order of release that we can get them.
Okay, so suffice to say, for purposes of us on the dais and members of the Senate today, the record is that if you get a judge somewhere, because you can move judges as needed in an emergency situation, that would begin to alleviate them. Is it fair to say that some of those judges might end up being confirmed in California but working somewhere else, or vice versa, at least some of the time, in order to ease court burden?
That's correct.
Okay, and you're not limited from doing that, so it is something that the court could find a way to do, even though it would have some cost.
Yeah, there's a mechanism for doing that. As I mentioned earlier, I've sat on the Ninth Circuit as a visiting judge. I've sat in Oklahoma, where we have an enormous caseload driven by the McGirt decision, which expanded federal jurisdiction in that state. I've sat in Colorado and New Mexico. And so judges, not just me, a lot of judges help out in emergencies.
Yeah, I might note that the Senate's major change between the House and Senate version was in fact related to Oklahoma and the perception of whether that was temporary or permanent.
We appreciate that.
Thank you. I'd ask unanimous consent that Mr. Hunt be waived onto the committee.
Thank you, Mr. Chairman.
Thank you. Without objection. He's a member. Okay.
Are you shielding?
Yeah. Pursuant to the rules, I now recognize myself and yield to Mr. Hunt.
Thank you, Mr. Chairman. We tried to solve this problem when we had a Democrat in office, and people say that we're not bipartisan. We can be when we want to be. Last Congress, I was a proud original co-sponsor of my colleague Darrell Iss's bill, the Judges Act. The Judges Act passed the Senate unanimously and passed the House in a bipartisan manner. However, despite the overwhelming support for the bill, President Biden voted against the Judges Act after President Trump got elected. President Biden also bragged about ignoring the Supreme Court's ruling that he didn't agree with. But now we're hearing that if President Trump ignores judges, we're in a constitutional crisis. So if everyone is following along, it means that a constitutional crisis only occurs when Republicans ignore federal judges. And the left is using activist judges to not only legislate from the bench, but also to encroach on the executive branch. The left will call it simple checks and balances, but everyone in this room who went to law school or can even read a civic book knows this playbook. The Democrats lost an election in overwhelming fashion, and now they are resorting to lawfare to prevent the will of the people from having their day. Is it justice delayed, or is it democracy delayed? The same party that raided the home of President Trump and weaponized the DOJ against President Trump is now using the limited power they have to delay reality.
What the left is experiencing isn't new. They are simply experiencing the 5 stages of grief. And unfortunately for them, they are stuck on stage 1, denial. The American people really need to get them to stage 5 as fast as possible, which is acceptance, because that's exactly what the American people voted for, and that's exactly where the American people are. This is the year 2025, and I want to help Democrats get to reality. This is the reality. The duly elected president of the United States is Donald Trump. President Trump is the leader of the executive branch. More than 77 million Americans voted for this result. Delaying the process of this administration is democracy delayed. This is called acceptance. You can't deny it any longer. Let's not play politics with the judiciary system. Let's pass the Judges Act and create more judgeships for our already overwhelmed federal judiciary. Everyone complains about the case backlogs, but we can fix it right here, right now. The American people deserve it. Do you know how we know that? Because the American people voted for it. And with that, I yield back the remainder of my time.
Would the gentleman yield for a question?
I yield my time back to the chairman.
Thank the gentleman. I'd yield to the ranking member for his question.
Thank you kindly. Just in the discussion about denial, it occurred to me whether the gentleman accepts that Joe Biden was the duly elected president from 2020. Is there an answer to that?
Since it's my time, I will acknowledge that the gentleman, former president from Delaware, was elected properly under the law, and I was there on January 6th, as were you, and that was so noted by the House and the Senate. But I appreciate the question. It is, in fact, something that I hope we can put behind us, is the question of whether or not the Electoral College, once making a decision, is final. It was final in 2020 or 2021, and it's final in 2025. That's a great question, but it's not one for our witness here today. I'm going to get you out of here a minute early, Your Honor. So I would say without objection, all members will have 5 legislative days in which to submit additional written questions for the witness and additional materials for the record. This concludes today's hearing, and I thank our witness for appearing before the committee today, and without objection, we stand adjourned.
Thank you.